Today we're going to talk about the various notices you may receive during a probate if you're an interested person. My name is Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. A couple caveats before we get going. This video is only for educational purposes. It is not legal advice. And secondly, we are going to be talking about Minnesota law here, Minnesota statutory law here. So if you have a question and you're in another jurisdiction, a lot of the theories and a lot of the procedures may be similar or the same, but you want to talk to an attorney that is in your jurisdiction to help you out. The first thing I want to do today is talk about a legal fiction that's out there, or I guess not a legal fiction, a Hollywood fiction, about notices that you may receive as an interested person, and that is the reading of the will. They generally doesn't exist. This was created by Hollywood as a plot device to get everyone in the same room and read a will and make a big dramatic moment. It just doesn't happen under the law. It's not required in any state that I'm aware of. I have heard of it happening once because the decedent specifically requested it in their will because they thought it would help with family harmony. However, even in that case, the attorney was a little bit confused as to why it was going on. And so was the family, because there's a lot of legal jargon in there that no one wants to sit through. That said, let's look at the stages of probate, because that's going to be important about what notices are given out during the probate. So if we boil it down, first we start off with the petition. And this is someone saying, I'd like to be personal representative and probate this will or probate the estate. And that is approved by the registrar or by the court. And again, it's not approval of the person as a personal representative or of the will as a probate. It's just approval of the petition to move forward. After the petition, we move to the notice period where notices are sent out. We'll be talking about this quite a bit. Third is the appointment. This could be either an appointment just by the registrar, or it could be a court hearing if it's a formal probate, where the individual that is applying to be personal representative is appointed and the estate is open to probate. And the will, if there is one, is approved and probated as well. The fourth thing that happens is the creditor claims period. This is a 4-month period starting back in the notice period where creditors have an opportunity to make claims on the estate. Once the creditor claims period is over, we go to the distribution where people get the assets that they are owed, and then finally we close the probate. So there are basically 5 notices that you may receive or that are going to go out there during the probate process, and let's talk about each one. The first one is the big one. It's the notice to interested parties. That happens right here during the notice period. It has to happen usually several weeks before the actual appointment hearing or date of appointment. What it does is it says, hey, Joe Schmo is applying to be a personal representative and trying to probate this will. It's going to go out to all the interested parties. And an interested party, it's a pretty broad list. It's anyone that might have an interest in the probate, which could include devisees in the will, heirs at law, beneficiaries of a trust. It could involve people who have equal or greater priority as personal representative. It could be spouse and children. And the last one, of course, is any known creditors. And we'll deal with unknown creditors in a minute. But right now, we just deal with those people you know are owed money because the decedent had debts. What this is doing is it's giving everyone notice that someone has applied. But it's more importantly, it's giving people an opportunity to object. And they have to object by the time of the appointment, or they have to show up at the hearing if there is one and lodge an objection there. The second notice is very similar. It actually happens during the notice period, but I'm going to write it in here. It's called the publication. I'll just write pub for now. This is an important date. What the publication does is it actually publishes the same notice you just sent out to all the interested parties, but it puts it in a legal newspaper, and the legal newspaper runs it once a week on the same day for 2 consecutive weeks. So if I were to publish it on Wednesday of this week, I would have to publish it on Wednesday of next week as well. When I say a legal newspaper, there are certain newspapers that are approved by the Secretary of State for legal notices to go into. Now, There's two sides of this. First of all, there's a legal presumption that everyone has been given notice once something has been published. That's kind of a legal fiction because nobody in their right mind sits there every day and reads the legal notices. It's just not an exciting read, even for an estate planning nerd like myself. However, there are major creditors, such as credit cards and banks, that do scan these legal notices on a regular basis. So if they are owed money by the decedent, then they can go ahead and make a claim on the estate. The third notice is going to be a little bit different. It's the notice to spouse and children. And this is in Rule 404 and 408 of the Rules of General Practice. It's actually not in the Probate Code. What the rule says is that the spouse must be given notice of their rights, of certain rights. If you notice, I said notice to spouse and children. In my practice, we send the notice to all the spouse and the children because they have similar rights. And every other attorney I've ever spoken with sent it to the spouse and the children, even though the children are not mentioned in the rules. The rules also don't say when the notice needs to go out. But realistically, the notice should go out right around the time of appointment, can go out anytime over here. It should go out well before the distribution so they can make a claim. And realistically, what we're talking about are notices of elective rights. These are exempt assets such as a homestead or an automobile or an allowance for money for support for the spouse and minor children or dependent children. That last one, the allowance, can start well before the creditor claim period. So you probably want to give them notice early on in it, even though the statute doesn't say when. The result of this notice going out is that the spouse and children can defend their rights to these allowances, to these assets that otherwise would go to creditors. The fourth notice that goes out, and it's not really a notice, but it is a document you will receive if you're an interested party or may receive, is the inventory. Now, this goes out to certain interested parties. It goes out to the spouse, and it goes out to the distributees. And it will go out to any other interested person or creditor who requests a copy of the inventory. Now, what is the inventory? It's just that. It's an inventory of all the assets that existed at the time of death. Not at the time of closing the estate. Now, you'll send out the inventory. You have to send it out within 9 months of the decedent's death or within 6 months of appointment of the personal representative, whichever one is later. So you should send out the inventory sometime within the creditor's claim period, earlier than later. And then if something changes, you learn of a new asset that you didn't know of, you went and opened the garage and they had a collector car there that you didn't know of when you sent the first inventory. You'll send a supplemental or augmented inventory down closer to the distribution and closer to the close of probate. By the time you hit distribution, you have to have an accurate inventory submitted or sent out to the appropriate parties. What does this do? It just gives everyone an idea what's in the estate so that they can make sure that what they can expect from the estate. Yeah. The fifth notice that goes out is, it's not really a notice, but it is the distribution, and it is a stack of papers that you may be receiving. And this is, if I'm owed $10,000 under a will, then I will get a check for $10,000. But usually this comes with a couple, caveats or requirements. There will usually be a receipt that you'll have to sign and fill out before you'll get the check, or that you have gotten the check. Or you may have to approve of the accounting before someone will send you a check. So there may be some other documentation that goes along with it. But in the end, it's right before closing. It's distributing the assets and what you may receive as a distributee of the estate. So that is my summary of the notices of the notices and paperwork you may get as part of a probate. If you like today's video, please feel free to smash that like and subscribe button. It really helps support the channel. Also, if you liked what you saw today, we do a new video every other Wednesday. We are in the middle or at the end of a probate series. I've got one more in this 10-part series. I'm not covering everything in probate, but covering the things that interest me right now and that my clients need to know, that I think other people would be interested in knowing as well. If you have any questions, leave them in the comments below or just send me an email. My email will be at the end of the video. Otherwise, until next time, this is Gregory Singleton with Signature Law.